Okay, so, we've been diving into some pretty heavy legal stuff lately, and this one you sent is no exception.
Yeah, this is a big one for sure.
Yeah, involuntary commitment and conservatorship.
Right.
A whole bunch of sources, and they're primarily focusing on California's Landerman-Petra Short Act.
Mm-hmm.
Um, and, I think our mission today is to try to, really kind of boil it down
Right.
to the core information, because I think this stuff can get really complicated really quickly.
It can.
And, we want to make sure that everyone understands, when and how these legal interventions can actually occur,
Exactly.
particularly, in cases of mental health
Yeah.
or when we're dealing with chronic alcoholism.
Right.
And it really is a system that's meant to try to protect people,
Yes.
right? Both the individual and the community at large.
Yeah. This
But
is supposed to be a safeguard.
it's the nuances of it
Yes.
that
Surely.
we really need to unpack, right?
Yep, exactly. And I think what we're really looking at is how this system is designed to offer support and care when individuals maybe can't or won't seek it themselves
Yeah.
due to a mental health crisis or chronic alcoholism.
Right.
And at the same time, thinking through how does it protect their rights,
Well
their
said.
autonomy throughout the process.
Hmm.
And I think the sources you sent, they give us a good path through that,
They do.
starting with the initial 72-hour hold
That's right.
and then potentially leading to longer-term conservatorship.
Yeah, and we're going to be looking at some, really pivotal points.
Yeah.
What are the conditions for that 72-hour hold?
Yeah.
What does it mean to be gravely disabled? What comes after that 72 hours?
Yeah.
Are there other holds?
Mm.
What are those like? And
Right.
this is a process that has some really, critical time sensitivities and legal ramifications. So let's just jump right in. Okay, so to start, I think it's really important to understand that the legal framework here really emphasizes that voluntary hospitalization is always the preferred first step,
Yes, absolutely.
right? Involuntary commitment is only considered when some pretty specific conditions are met.
Right.
So
Yeah.
we're talking about a situation where, someone is in imminent danger to themselves or others,
Mhm.
or if they're considered gravely disabled.
Yeah.
But it's important to understand that that danger or that, grave disability
Mhm.
has to be because of a mental disorder or chronic alcoholism,
Exactly.
right? And the individual also has to have either refuse voluntary treatment or just be unable to, comply with those recommendations for voluntary treatment.
Yeah.
So it's not just, someone needing help.
Right.
It's a very specific set of legal thresholds.
It is.
Okay, so with that in mind,
Okay.
let's focus on that initial 72-hour hold.
Okay.
So you sent some material that points to two sections within the Welfare and Institutions Code.
Section 5150, which deals with mental disorders, and then Section 5230, which is about impairment from alcohol or drugs.
Okay.
So what are the main similarities and differences between these two?
Well, they're similar in that they both allow for that 72-hour detention for evaluation and treatment
Okay.
if there's probable cause to believe that someone is a danger to themselves or others,
Yes.
or gravely disabled,
Okay.
whether it's because of a mental disorder or because of impairment by chronic alcoholism
Okay.
or drug use.
So it's the same principle.
The principle is the same. The
Yeah.
difference is the root cause of the danger.
Got it.
5150 focuses on mental disorder.
Uh-huh.
5230 is specifically about impairment from substance use.
Okay. That makes sense.
Mm.
And who can actually initiate this 72-hour hold?
Okay, so the law is very specific about who can actually do that.
Okay.
It's peace officers,
Mm-hmm.
staff at approved evaluation facilities,
Okay.
members of mobile crisis teams, and other professionals that are designated by the county.
But the important thing is all of them have to have probable cause
Right,
to believe that the person meets the criteria.
right. Being a danger or gravely disabled
Exactly.
because of mental disorder or substance use.
Yes.
Okay, now you mentioned that the term mental disorder isn't actually clearly defined in those sections.
Yeah, that's interesting.
But that California courts generally look to the DSM.
Right. The Diagnostic and Statistical Manual of Mental Disorders.
Right. Why is that?
Well, the legal code doesn't have a specific list of disorders.
Mm-hmm.
So the courts have sort of aligned with the clinical standards outlined in the DSM
Okay.
when they're interpreting the term.
Okay, so they're trying to have a common language.
Exactly, a common clinical language.
Yeah.
So there's at least, a recognized basis for detention,
Okay,
not just subjective observations.
right. So it's not just someone's opinion. It's there's something to back it up.
Right, exactly.
Okay, so we get the danger to self or others part.
Mm-hmm.
But the term gravely disabled, comes up a lot.
It does.
And I feel like that's a term that could be kind of open to interpretation.
Yeah, it definitely seems like it could be subjective.
So what is the actual legal definition of that?
So thankfully, we have the Welfare and Institutions Code,
Okay.
Section 5008, and it gives us two specific situations.
Okay.
First is being unable to provide for your own basic needs.
Like food, clothing, shelter, that sort of thing?
Exactly, food, clothing, shelter.
Okay.
The second situation is if someone is found mentally incompetent in a felony case that involves serious harm,
Okay.
where their mental disorder prevents them from understanding the legal proceedings or assisting in their defense.
Okay, so that's pretty specific.
Yeah.
And I guess it also is important to point out what gravely disabled does not include.
Right.
Your sources mention intellectual disabilities.
Exactly.
Right.
The law is very clear that having an intellectual disability does not automatically make someone gravely disabled.
Right, so it has to be that combination of the mental disorder or chronic alcoholism,
Right. It's got to be that root cause.
leading to the inability to care for themselves.
Yes, exactly.
Okay, so let's say someone is concerned about an individual.
Okay.
Maybe it's a family member or even a psychologist.
Uh-huh.
And they think this person meets the criteria for a 72-hour hold.
Okay.
What is their role in actually starting that process?
So there's an important distinction here.
Okay.
Anyone can initiate the process by calling the authorities, like
Yeah.
the police, a mobile crisis team, whatever.
Right.
But only certain professionals can actually institute the hold.
Okay.
Peace officers,
Uh-huh.
designated facility staff, those kinds of folks.
Got it.
Now, a psychologist who works at a hospital that's approved for these holds,
Mhm.
they can admit someone,
Okay.
but otherwise they have to contact those authorized entities to request an evaluation.
So it's kind of like a checks and balances thing.
Right. You want to make sure these interventions are based on professional judgment.
Right, to prevent like unwarranted detentions.
Yeah.
So once someone is actually placed on a 72-hour hold,
Yeah.
what happens?
Well, it's not just a waiting period.
Right.
It's not just sitting around for 3 days.
Okay.
The law says a thorough evaluation has to begin right away.
Okay.
And during the 72 hours, the person gets treatment,
Yeah.
whatever care their condition needs.
Okay.
And importantly, they have to be released before the 72 hours are up if the psychiatrist decides they don't need more evaluation or treatment.
Okay, so it's not a guaranteed 72 hours.
Right. It depends on the psychiatrist's assessment.
What if other professionals think the person should be released, but the psychiatrist doesn't agree?
In that case, it goes to the medical director of the facility.
Okay.
They make the final call.
So the psychiatrist has a lot of power here.
Yeah, they're really central to these decisions.
At the end of the 72 hours, what are the possible outcomes?
Okay, so there are 4 main possibilities.
Okay.
1, they could be released if they no longer meet the criteria.
Okay.
2, they could be referred for voluntary treatment if they're now willing to get help.
Okay.
3, the facility could start the process to certify them for more involuntary treatment if they still meet the requirements.
Right.
Or 4, they could start the process of getting a conservatorship.
Okay, we'll talk about that later.
Yeah.
But first, let's move on to what happens after that initial 72 hours.
Okay.
So we have these subsequent involuntary holds.
Mm-hmm.
The first one is the 14-day hold or a 5250.
Right.
So what leads to this next level of intervention?
So basically, if after the 72 hours the person is still a danger or gravely disabled
What?
because of a mental disorder or chronic alcoholism,
Mm-hmm.
and they haven't agreed to treatment,
Okay.
then they can be put on a 14-day hold.
So it's like the same concerns as before.
Exactly.
But now they're getting more intensive treatment and evaluation for a longer period.
Right. It's about making sure they're getting the care they need.
And this isn't just automatic. Is there a process for initiating this?
Yes, there's a specific notification and certification process.
Okay.
It's all detailed in the Welfare and Institutions Code,
Okay.
sections 5251 and 5253.
Okay.
Basically, 2 people have to sign a written notice.
Okay.
The person in charge of the evaluation services,
Right.
or their representative,
Okay.
and a doctor or psychologist who was involved in the evaluation.
How's that?
And this notice has to be given directly to the person
Right.
and to their attorney or advocate if they have one.
Okay.
And really importantly, they have to be told about their rights.
Okay. What rights?
They have the right to a certification review hearing
Oh, what?
and the right to seek judicial review through a writ of habeas corpus.
So they can challenge this hold.
Exactly. They have options.
So let's talk about the certification review hearing first.
Okay.
What happens there?
So this hearing usually has to happen within 4 days of the certification,
Okay.
unless they've already requested judicial review.
Right. Habeas corpus.
Yeah.
Okay.
Now, there can be some short postponements. especially in smaller counties,
Mm.
but it's usually a pretty quick process.
Got it.
The person can choose to waive the hearing entirely,
Okay.
or they can waive their presence at the hearing.
Okay.
And the hearing itself is run by a neutral person
Okay.
appointed by the court.
So it's not like the people who initiated the hold are running the hearing?
No, it's someone completely independent,
Okay.
and their job is to decide if there's enough reason to keep the person detained for the 14 days.
Okay, so they're making sure it's justified.
Exactly.
And the other option is the writ of habeas corpus.
Right, that's the judicial review.
How does that work?
So that's usually filed in the Superior Court,
Okay.
either where the treatment facility is or where the 72-hour evaluation happened.
Okay.
But the facility has to be told in writing that the person is going to seek judicial review.
Okay, so they can't just spring it on them?
Right. They have to be given notice.
And the person has the right to a lawyer, right?
Yes, if they want to pursue this.
Hmm.
The court appoints them a lawyer.
Yeah.
Could be a public defender or another attorney.
Got it. And then what?
Then the court has 2 days
Yeah.
to either release the person or schedule a hearing to look at the reasons for the detention.
Okay, so again, there are checks in place
Right. It's not just a rubber stamp.
to make sure their rights are being protected.
Exactly.
What happens at the end of the 14 days?
So it's similar to the 72-hour hold.
Okay.
They could be released, referred for voluntary treatment,
Mm-hmm.
put on a post-certification hold,
Okay.
or they could start the process for a conservatorship.
Okay, so you mentioned post-certification holds,
Right?
and it sounds like those are different depending on why the person was initially held.
Yes, there are a few different types.
Okay. Your sources talk about a second 14-day hold for suicidal behavior, a 30-day hold for people who are still gravely disabled,
Right.
and even a 180-day hold if someone is a danger to others.
Yeah.
Let's break those down one by one.
Okay.
Starting with that second 14-day hold for suicidal behavior.
Okay.
What are the conditions for that?
So this one applies if during either the initial 72 hours or the first 14 days,
Okay.
the person threatened or tried to kill themselves,
Okay.
or if they were originally detained because they were suicidal
Right.
and they're still considered an imminent threat.
So the risk is ongoing.
Right. They're still a danger to themselves.
Okay.
Now, a certification review hearing isn't automatically required for this hold,
Okay.
but they can still request a habeas corpus hearing.
Right. So they still have that option to challenge it.
Absolutely.
And who decides when to release someone from this type of hold?
It has to be the psychiatrist who's treating them.
Okay.
Or if a psychiatrist and a psychologist have been working together on the case and they both agree,
Okay.
they can authorize release together.
Okay.
But if they disagree, it goes to the medical director.
Okay. So again, the medical director is the tiebreaker.
Right. They have the final say.
And what are the possible outcomes after this second 14 days?
Same as before release referral for voluntary treatment or starting the process for a conservatorship.
Okay. So now let's talk about the 30-day hold for people who are still gravely disabled.
Okay.
What are the criteria for that one?
This one comes after the first 14 days.
Okay.
If the treatment team decides the person is still gravely disabled
Uh-huh.
because of a mental disorder or chronic alcoholism,
Okay.
and they're still not willing or able to get voluntary treatment.
So it's like the same concerns, but now it's a longer period of time.
Exactly. And
Right.
it's important to note that this only applies in counties that have specifically chosen to use it.
Oh, interesting. So it's not statewide.
No, it depends on the county.
Okay.
And they still have the right to a certification review hearing.
Okay.
And they can still file a habeas corpus.
Right. So their rights are still protected.
Exactly.
At the end of the 30 days, what can happen?
They could be released,
Okay.
referred for voluntary treatment,
Mhm.
certified as imminently dangerous.
Which could lead to that 180-day hold we talked about.
Right, exactly. Or they could start the conservatorship process.
Okay. So finally, we have the 180-day hold for people who are a danger to others.
Right. This one's a big one.
Yeah, this sounds like the most restrictive of the short-term holds.
It is. It's a serious intervention.
What are the conditions for this?
So this applies if the person actually tried to hurt someone
Okay.
or threatened to hurt someone
Okay.
while they were in custody for the initial evaluation,
Okay.
or if it happened right before they were taken into custody.
Okay.
And it has to be because of a mental disorder.
Right. So there has to be a clear link.
Yes, it has to be a direct result of their mental state.
Yeah.
For this hold, the district attorney has to file a petition with the court,
Okay.
and there has to be a hearing within 4 days.
Okay.
or 10 days if the person wants a jury trial.
Okay, so it's a much more formal process?
It's a much higher bar,
Okay.
and they can still file a habeas corpus at any point.
Right, so they still have that, right?
Yes.
At the end of the 180 days, what are the options?
They can be released,
Okay.
referred for voluntary treatment,
Hmm.
or the facility can file a new petition to have them certified as imminently dangerous again.
So it can be extended.
Yes, if the concerns are still there.
Okay, so we've talked about all these different types of involuntary holds,
Right.
which are all meant to be relatively short term.
Yes.
But now let's move on to conservatorship.
Okay.
Your sources describe this as a longer-term arrangement for someone who's gravely disabled.
Exactly.
What does that actually involve?
So the court can appoint a conservator for someone
Okay.
if they're found to be gravely disabled because of a mental disorder or chronic alcoholism.
And who makes that determination about being gravely disabled?
It's ultimately up to the court
Okay.
based on evaluations and recommendations.
Okay.
And these conservatorships can be temporary, like 30 days or long-term, a year at a time. But they can be renewed if the person is still considered gravely disabled.
And your sources specifically address the definition of gravely disabled in this context,
Yes.
especially when it comes to help from family and friends.
Right. That's a key point.
So what's the deal with that?
So the law says someone can't be considered gravely disabled
Okay.
if they can survive safely in the community
Mm-hmm.
with help from family or friends.
Okay.
But, and this is important,
Okay.
that help has to be offered in writing to the court.
Oh, so it's not enough for people to just say they'll help?
No, it has to be official.
They have to put it in writing.
Exactly.
Okay, so what happens once a conservatorship is in place?
So within 10 days,
Okay.
they have to develop an individualized treatment plan for the person,
Okay.
unless the court says treatment isn't appropriate.
Okay.
And if the treatment goals are met
Mm-hmm.
and the person isn't gravely disabled anymore,
Okay.
then the conservatorship has to be terminated.
So it's not meant to be permanent.
Right? It's supposed to help them get to a point where they can function on their own.
Okay, now lastly, your sources talk about involuntary commitment for minors.
Yeah.
And usually parents or guardians have to give permission for a minor to be hospitalized.
Right.
But there are exceptions.
There are.
What are those?
So if a minor is a danger to themselves or others
Okay.
or gravely disabled because
Right.
of a mental disorder,
Okay.
and the parent or guardian isn't available to give consent for treatment,
Okay.
then they can be put on a 72-hour hold.
And who can initiate that hold?
It's the same people as for adults.
Okay. Peace officers, hospital staff, and so on.
Right.
Okay.
But they have to try to notify the parents or guardians as soon as possible.
Right. So they still have to be involved.
Yes, they have to be informed.
And how is gravely disabled defined for minors?
It's a little different than for adults.
Okay. How so?
It means the minor can't use the basic things they need,
Okay.
like food, clothing, shelter, to the point where it's really endangering their health, safety, or development, even if other people are providing those things.
So it's not just about having access to those things.
Right. It's about being able to use them.
Okay.
And it's important to note that certain things don't automatically qualify as a mental disorder.
Okay. Like what?
Intellectual disability,
Uh-huh.
epilepsy, developmental disabilities,
Okay.
alcoholism, drug abuse, antisocial behavior.
Okay. So those things on their own don't count.
Right. It has to be a diagnosed mental disorder that's causing the problem.
Okay. So once a minor is on this hold, what happens next?
So they have to have a clinical evaluation,
Okay.
and then they develop a treatment plan
Okay.
that has to identify the least restrictive placement
Okay.
where they can get treatment.
Got it.
And they have to talk to the family and the minor
Okay.
about the treatment options and where they might be placed.
So everyone's involved in the decision-making process,
Right. As much as possible.
and they have to try to get consent from the parents.
Yeah.
But if they can't get consent,
Right.
they could still treat the minor.
Yes. If they meet the criteria.
Okay, wow, that's a lot of information.
It is. It's a complex area of law.
Yeah, thank you for breaking it all down for us.
It's important to understand this stuff.
It really is.
Yeah.
So to you, our listener, we hope this deep dive into involuntary commitment and conservatorship has given you some clarity on this complicated issue.
Yeah. It's all about balancing individual rights with the need to intervene when people are in crisis.
Right, so it's a tough balance to strike.
It is.
And I think one thing that's really interesting to think about is how we define these terms.
Yeah.
Like, danger to self or others.
Yeah.
And gravely disabled.
Those are big concepts.
Yeah, and how do those definitions change as our understanding of mental health changes?
Exactly. And how do they play out in different situations?
Right, like what might be considered dangerous in one context might not be in another.
It's a lot to think about.
It is, and it's something that we as a society need to keep talking about. So thank you for joining us on this deep dive, and we'll see you next time.
Thanks for having me.